Provisions. Article 88. The absolute community of property between spouses shall commence at the precise moment that the marriage is celebrated. Any stipulation, express or implied, for the commencement of the community regime at any other time shall be void. 145a. Article 89. No waiver of rights, shares, and effects of the absolute community of property during the marriage can be made except in case of judicial separation of property. When the waiver takes place upon a judicial separation of property, or after the marriage has been dissolved or annulled, the same shall appear in a public instrument and shall be recorded as provided in Article 77. The creditors of the spouse who made such waiver may petition the court to rescind the waiver to the extent of the amount sufficient to cover the amount of their credits. 146a, Art. 90. The provisions on co-ownership shall apply to the absolute community of property between the spouses in all matters not provided for in this chapter. N. Section 2. What constitutes community property? Article 91. Unless otherwise provided in this chapter or in the marriage settlements, the community property shall consist of all the property owned by the spouses at the time of the celebration of the marriage or acquired thereafter. 197a. Article 92. The following shall be excluded from the community property: property acquired during the marriage by gratuitous title by either spouse, and the fruits as well as the income thereof, if any, unless it is expressly provided by the donor, testator, or grantor that they shall form part of the community property. Property for personal and exclusive use of either spouse. However, jewelry shall form part of the community property. Property acquired before the marriage by either spouse who has legitimate descendants by a former marriage, and the fruits as well as the income, if any, of such property. 201a. Article 93. Property acquired during the marriage is presumed to belong to the community, unless it is proved that it is one of those excluded therefrom. 160. Art. 99. The absolute community terminates upon the death of either spouse. When there is a decree of legal separation. When the marriage is annulled or declared void, or in case of judicial separation of property during the marriage under Article 134 to 138. 175a. Art. 100. The separation in fact between husband and wife shall not affect the regime of absolute community except that the spouse who leaves the conjugal home or refuses to live therein, without just cause, shall not have the right to be supported. When the consent of one spouse to any transaction of the other is required by law, judicial authorization shall be obtained. In a summary proceeding. In the absence of sufficient community property, the separate property of both spouses shall be solidarily liable for the support of the family. The spouse present shall, upon proper petition in a summary proceeding, be given judicial authority to administer or encumber any specific separate property of the other spouse and use the fruits or proceeds thereof to satisfy the latter's share. 178a. Conjugal partnership of gains. Section 1. General provision.